is a dangerous place, unfortunately.
Well, I was gonna say, I'm not sure what the city may be.
And I thought Valley Brook was a bad place.
Exactly. We may beat them in per capita deaths upstairs, you know. That's crazy.
So we're gonna have, you getting that all figured out now?
Yeah.
Thank you.
It's progress in this. I'm sure he is. And I did, I was thinking, my daughter, because she.
Gotta get them fun little.
She loved it. He says, Dad.
Good news.
Oh, I get you. I have to have
Just.
We literally just showed each other. He was like, he said it happened last, no, it happened last.
It's an old.
But it was like, I mean, it happened last week, we were doing the alerts and stuff. The timing on it could not have been, but then we both missed each other.
How long you guys recording this thing? That's what I selfishly I got to get done tonight, so I was thinking about asking him how much time do we have. We kind of is in this shit. So is there not an option for the? You guys are first, right? There's only 3 things he's got to look at. It's not that complicated. We agree.
Okay, we already did it once. All right.
Haven't we?
So how
I
far?
think we
I
retired
slept
on
really
it
bad,
right
but
now.
it was 2 months.
No, so,
You feigned
Sabrina's
sleep.
gonna argue with one of Ray's gonna give it up. I don't think it'll be. Okay.
sounds nice though.
Exactly. You could use a little bit of that.
Yeah.
You want me to go party or what?
That's what just if dude didn't read my email. That's what I said.
I don't get it.
Enter your attendee ID number, followed by pound. If you do not know your attendee number, press pound to continue.
Good afternoon, everybody. You may be seated.
Well, in the briefs that the state and Johnson & Johnson submitted regarding the state's proposed judgment, the parties addressed 5 areas or points of disagreement about the proposed judgment. Johnson & Johnson also included a sixth topic, which I'm going to consider as a motion for a new trial, and the state responded to that. The August 26th judgment is not a final appealable judgment. Until the court enters a final judgment, any motion for a new trial pursuant to 12 OS Section 653C is premature. So therefore, I don't see a need to address the arguments related to the new trial at today's hearing. What I would like to do is invite counsel for the state and Johnson & Johnson to make oral arguments on the other 5 areas. And rather than address each one and chop it up, what I'd prefer is that each side use their time and address all 5 areas at the same time. I'll also give each side an opportunity to make rebuttal arguments. So I haven't really ever given you time constraints, but it seems like we ought to be able to knock out each side in 30 to 40 minutes. So if we get much past beyond that, I'll probably start looking at the clock. I'd call on the state to go first. Mr. Beckworth.
May it please the court. Your Honor, Brad Beckworth for the state of Oklahoma. It's a pleasure to be here again. I know everybody misses us. We miss y'all, but I'm sure we're glad to be back home. Your Honor, this is an interesting and kind of unique position for us to be in because we've argued so many of these points for so long in front of Your Honor. And I think for all of us, certainly myself, the evidentiary record in this case is as robust and complete as any I've ever been involved in. So I feel like when you entered your order, you had all the evidence you needed and the arguments had been made, and frankly, only Your Honor knows what Your Honor intended certain things to mean. I think from the state's position, there are 3 main points to address. And I'm going to start with this issue of settlement credits. We have a little bit of a PowerPoint, really, it's just to show you a few things. But I think the settlement credit issue's very simple. Your order doesn't mention settlement credits. Now, in the findings of fact that we proposed, we addressed the potential for joint and several liability and how settlement credits would work. We also asked for $17 billion. We didn't get everything we wanted, at least at the way it was phrased by Your Honor. But the way those findings of fact work from both sides is that they are proposed. The defendants themselves did not propose a finding of joint and several liability against any of the settling defendants. It's as simple as that. Nor did they put on any evidence of it. And before I go to this, let me just say something about that $17 billion. We're going to come back to that and continuing jurisdiction in just a moment. But to just deal with the settlement credits first. Your Honor is very familiar with this, but 12 OS 832H is the operative statute. And of course, settlement credits can be given in a joint and several case. But to have it, you have to have another defendant be found liable in tort for the same injury. And we underline the relevant part there. Liable in tort for the same injury. We never had that happen in this case. There's a case directly on point, Nichols versus Mid-Continent Pipeline Company, that deals with this very same issue. I'm sure Your Honor's read the briefs, but in that case, one of the defendants wanted to get a credit for a empty chair ghost tortfeasor liability. It was a nuisance and negligence case. Here, the ghost tortfeasors would be the Purdue and Teva entities. The Supreme Court rejected any finding of a settlement credit related to settlements with the empty chair defendants because the defendant never submitted the issue of liability for that ghost tortfeasor to the finder of fact. And the court made it very clear that prior to, in this case it was jury trial, but prior to discharge of the fact finder, the defendant had to submit the question of fault of a tortfeasor in order to get a settlement credit. Here, that was never done. We'll talk about it here in just a second, but not only was it never done, but also there was never any evidence put on by Johnson & Johnson about liability of any of the other settling defendants, none whatsoever, which is a very, very important fact here as we go forward. So in order to have a settlement credit finding, you're going to have to request a finding of liability against the ghost tortfeasor. Then you're going to have to put on evidence that supports such a finding of liability. And then you have to actually obtain a finding. And Johnson & Johnson says that in their pretrial order, they reference joint and several liability and settlement credits. But it wasn't in their findings of fact. It's not in their objection that they filed. Even today, they don't stand here in any of their briefs and say that that Teva or Purdue are liable. In fact, all of their submissions have been that nobody's liable except some Mexican drug cartels. So there simply was no such evidence. Now, what J&J's position was, and we saw this in their motion in limine, and you heard them argue a lot of times when I was talking in court that they're trying to make this case about Purdue. And this is what J&J said with respect to Purdue. Because Purdue settled its claims with the state, evidence and argument regarding its conduct is no longer relevant to establishing Purdue's liability. Well, that's true and false. It certainly was true with us presenting our case, but it's not true at all if they wanted to have a finding of liability so they could get a credit for J&J. I'm sorry, for Purdue. Also, I think it's interesting, we searched it, but in their proposed findings of fact, I don't think they mentioned Teva at all. I don't think the name Teva is there. I may be wrong, but I'm pretty sure of that. You can skip to the next page. So, Your Honor, we had not only not have a request anywhere for a finding of liability, but there was no evidence put on at all. And Your Honor sat through 8 weeks of this trial. Nowhere did anyone on J&J's side prove that Purdue was liable. No one proved that Teva was liable at all. We talked about some of the conduct that they engaged in. You mentioned in your order concerted activity, but a lot of that had to do with promotional activity and supply and things like that. The specific conduct that you found throughout your order regarding false misrepresentations and omissions was 100% limited to Johnson & Johnson's conduct. That was the only question before you. And as I read it, I can't get into your mind, but as I read it, that was the only finding that you made at any point in time. Never did you say Purdue or Teva or anyone else's marketing was false or misleading or constituted a nuisance. And in order for them to have a settlement credit, you didn't just have to find that these other defendants' conduct was false, misleading. You would have had to have found that it rose to the level of causing a nuisance. So if we go to the next one, Nate. So when you skip all those steps that Johnson & Johnson skipped, they're left with one and only thing. Somehow, would our settlement agreements with Purdue or Teva get J&J off the hook? Let me just stop there for a second. We all had our reasons and strategies for doing different things. We certainly talked about joint and several liability a lot when we talked about the potential of a joint tortfeasor going and being able to get contribution down the road. For whatever reason, they strategically chose not to do that. I think we all know why. I mean, they have multiple cases out there. Johnson & Johnson just settled the first MDL trial in Cleveland, Ohio. Purdue filed for bankruptcy as we predicted it would. Teva's still sitting there ready to go to trial. They've all worked together as we've suggested here. They're working together there too. There's no way they could sit on Purdue and Teva in this trial and try to pop them for joint and several liability as joint tortfeasors, because that would have killed them all in all their down the line cases. So they had to make a strategy choice not to do it. They have to live with that. So we then look to the settlement issue, and if you go back, Nathan, the case we were just talking about, Nichols, talks about if you didn't submit it and get a finding, then you got to look to the settlement agreement that's at issue itself. So we pulled up our settlement agreements. Here, when we look at Purdue's, page 4 and 5, we specifically refer to J&J and the related entities as non-settling defendants. We did the same thing at pages 4 and 5 of Teva. Non-settling defendants refer to Johnson & Johnson and all its related entities. So, Your Honor, I think just as simple as can be, you wrote your order, so again, only you know what you meant, but there is no finding. There was none requested. Our settlement agreements don't deal with it, except to completely accept J&J from being involved in either of those settlements. And so under clear Supreme Court precedent and a black letter statute, that's just the end of the issue as far as we see it. They can argue what they want to argue, but I don't think they have any credible arguments on that at all. So, Your Honor, the second issue that I'll address is the one about continuing jurisdiction and whether 572 means 572 or maybe something more up to the $17 billion that we originally requested. And within that, I'm going to kind of subsume in that argument this issue of whether you made a $100 million typographical error, as they have alleged. Let's just start here with some of your findings. Your Honor, I think the findings that you made trigger certain additional duties on the court that are inalienable. And I'll just run through these real quick. You found that the defendants engaged in unlawful acts. You found that those acts created a nuisance. And you found that the nuisance fell within the four corners of Oklahoma's nuisance law. When you did that, rightfully, you had to make a decision about whether the nuisance that had been created was permanent or temporary. As we talked about when we were dealing with whether we'd have a bench or jury trial, the issue is if it's permanent, then it's got to look at damages, and if it's temporary, then it can be abated and we can go into equity. So you made the necessary finding there. The nuisance can be abated, which is the right finding, was fully supported by all the evidence in this case. There was no person on either side that said the nuisance, if there was one, could not be abated. So that finding is fully supported by the record, and that's what you did. So you then went to the third step. The proper remedy for a nuisance is equitable abatement. And you found that the appropriate remedy to address the opioid crisis is the abatement of the nuisance. Your Honor, you're right there too. That is what the law requires. When a court sitting in equity finds each of these things to occur and you have a temporary nuisance, the only thing the court can do is abate it. And you can't abate it halfway. You have to abate it all the way. So if we can go to the next one, you then went on, and I hate to tell you about what you did because I know you wrote it, but we'll kind of build to this. We had an abatement plan, which you know, it's entered into evidence. That's a defined term, abatement plan, and you defined it and capitalized it here. You found that our abatement plan was reasonable and necessary to abate the public nuisance. And you went on to say that you would execute it as follows. So let's just stop there for a second. When Your Honor found that the nuisance could be abated, Your Honor took on a legal obligation in equity that you have to actually abate the nuisance. And in looking at how that's going to be done, you found, as a matter of law and fact, that our abatement plan, a defined term abatement plan, is the way to do it. And you found that that abatement plan is reasonable and necessary. So our abatement plan laid it out on what needed to be done. The four corners of it talked about, for year one, $870 million, carrying forward for 10, 20, 30 years. So when you did that, we read it and we looked at continuing jurisdiction, because you said later on at the end of your order that the court would have continuing jurisdiction. You also said that you were constrained by factors and that 572 was all that you could do at this time. Now, I think J&J read that to say that you were doing a one-time award of $572 million. We read your order, as you wrote it, with what the law of Oklahoma and elsewhere would require to say that that's not possible, that $572 million or just doing it 1 year isn't the standard. The standard is, Your Honor must maintain jurisdiction as a court in equity over this matter until the nuisance is abated. Because when you come into court and request equitable relief to abate a nuisance, the only entity that has the power, control, and authority to actually abate it is Your Honor. And I think, Your Honor, we could have easily done this case different. You could have ordered us to do it in phases, where we get to the liability stage and then come on and talk about what the abatement remedy is, but we all chose to do it in, one fell swoop. So nothing in that order, now again, I'm not in your mind, but nothing written and nothing in the law would suggest that it could be a 1-year deal. And I think more importantly, the law and facts just don't allow that. So we believe, and we'll get to the case law in just a second, but that Your Honor has a duty that's inalienable, that you don't have a choice but to fully abate this nuisance. When we look at what the testimony was in this case, you heard Commissioner White, who's not here today, and several others talk about it. Even our first witness, the historian, talked about how in the past history it took 20, 30 years to abate the nuisances that we had had in the past with crisis from heroin problems. It's always been something that takes years and years and years of re-education and treatment. Here we had at least 3 state employees, none of whom were paid, all of whom you qualified as experts, testify that the plan would take at least 20 years. Not 1 year, not short of 20 years, but at least 20 years. The defendants did not have an opposing expert on abatement, not one. Their one witness testified here as kind of an expert on liability issues, but during discovery, they put him on for the issue of abatement. And we talk about it in our abatement plan in Dr. Room's report, that the testimony from J&J and even Purdue when they were still in the case was that abating this nuisance, this crisis, would be expensive and take a very long time on behalf of a lot of different entities. Critically important here is that the defendants never put on a counter abatement plan. There just was no controverting proof to anything. There was cross-examination, but no counter proof, no one to dispute anything. And Your Honor, I don't know if you remember from law school, you and I are similar age, but when I was in law school right before it, Joe Jamel had won the Pennzoil versus Texaco case. It was a breach of contract case. I think the award was $7 billion by a jury. It was tried in Texas, and it was truthfully over a handshake deal. And Texaco made a very bad decision in that case. They were so confident they were going to win on liability, they didn't put on any damages experts, none. They had no competing view of damages. So when the plaintiff won that trial, the defendant, because liability had entered, they were in trouble. They had nothing to counter the plaintiff's damages model on the breach of contract claim. They got hit for $7 billion. At that time, I think that was the largest verdict in U.S. history. We have a very similar situation here. So let's just go to what the law requires. You've heard me say inalienable duty several times, and I mean it. When you have a nuisance case, really any equity case, but in a nuisance case, once you find under equity that a nuisance exists and can be abated, it's the court's job to remove it. The Henching case that we cited talks about prescribing a method, timing, and procedure. One of the cases, the crushed stone case we talked about, the court came in long after the original trial and had post-hearings to determine whether the nuisance had been abated and what all needed to be done to do it. That's something that happens under Oklahoma law. It happens in a lot of different equitable situations. But the key is that language, if you go back, Nathan, it becomes the trial court's duty under its equitable powers to order the nuisance removed. When you found that our abatement plan was reasonable and necessary, it, in my opinion, became your duty and one that you cannot push to anyone else. And we heard what you said about the legislature, and I think, I can't guess what you were saying, but encouraging other folks to take steps. Be that as it may, the court has to do what equity requires. So we don't think there's a choice there, and we can look at how that happens. Nathan, go to the next one, please. This is from another Oklahoma Supreme Court case. It's not a nuisance case, but it's dealing with equity. I think this is really important to talk about the flexibility that a court has, because I understand what you said. What Your Honor, as I read it, what Your Honor said was, we said that it was a 20-year plan. Your Honor didn't find proof that it was 20. So you said, I'm constrained to do 1 year. But I think no one testified that it would just be a year. It was many, many years. So if Your Honor didn't find that it's 20, I think the evidence was undeniable from our side, and again, we were the only ones that put on witnesses on this, that it would take many, many, many years. So we'll get to this in just a second, but I think the right way to do this under continuing jurisdiction, if you haven't found a year certain, we certainly put on evidence that the nuisance was going to be something that had to be dealt with for many, many years in very broad, sweeping terms. And so the way to deal with that is to use your continuing jurisdiction to come back year after year and say, okay, I ordered 572, here's where it is. Where are we now? Is that enough? Do we need to go again? Do we need to do the next phase of the plan? Because the plan's there. I think we're largely limited to the four corners of that, but the plan's there. This case talks about this, what I would call an elastic or flexible approach. I won't read the whole thing, but what the court is saying is that our Supreme Court held that when equity attaches in a proper proceeding, it will administer complete relief on all issues properly raised by the evidence, regardless of whether they are specifically raised by the pleadings. It goes on to talk about, here in the last sentence, in other words, the plastic remedies of equity are molded to the needs of justice and are employed to protect the equities of all parties. And the flexibility of equitable jurisdiction permits innovations and remedies to meet all varieties of circumstances which may arise in any case. Moreover, the fact that there is no precedent for the precise relief sought is of no consequence. And you can read the rest of this, Your Honor, but it talks about the broad plenary power you have as a court in equity, and that your purpose in accomplishing justice has to be fulfilled. So what that tells us is there's nothing in the law more broad than the equitable powers of a trial court when they sit in equity. Because unlike a case where you just award damages and someone says, here, I lost a $10 million painting and the painting's valued at $10 million, so that makes me whole. In a deal like this, the remedy has to be abatement, which is an equitable order. And Your Honor said it yourself. You know, you hit all the elements of our statute that it affects a community as a whole. You said that the harm and the increases in harm have been exponential, but you used the word menace, that this nuisance is a menace to Oklahoma. And I know you believe that because you wrote it and you signed your name to it. I also know you had to believe it because you sat here and heard it and you saw the tears that were shed. And I'm sure you know from all that you've heard how bad this is, and that's why you wrote what you wrote. Your Honor, if you believe it to be a menace and a nuisance that can be abated, we cannot stop short. We can't do it. And I don't think you can do it, with all due respect. I don't think you have that option. And I said something to you more than once in this case, and you know, we're all good advocates, and this is one of the best ones I know sitting by me. We say things for advocacy and rhetoric, but I said something to you that I meant with all my heart when I talked about having the courage to do the right thing legally, factually, and morally. That was something that we built into our case from day one. And I talked about passing that on to you. I know the burdens that you have as the single fact finder in this case. And I know the machine that we're up against. I've watched the press conferences. I've read the interviews. One of the nice young ladies who interviewed Johnson & Johnson's here in the courtroom, and I listened to that one very carefully. I've never heard a defendant say as bad of things about a finding as were said here. I know it takes a lot of courage to stand up to that. But we're all left where we had to give this case to you because that's what the law requires. And the law doesn't allow us to stop short of success. It just doesn't. And we can look at other examples of this throughout the law, and Judge Burge is going to talk about one here briefly in just a minute. But Nathan, if you go to the next, this one here. So some examples, you know, we know that school segregation has been an issue forever. My partner Jeff Angelovich and I lived in Longview, Texas forever. They're still dealing with desegregation orders in the school system. My wife was a teacher in a community-based school that was a major segregation problem. Kids had to still get bused into them. You deal with that all over the country, and what has happened in those cases is when a judge gets one of those cases, they have to issue, if they find it appropriate, an order to fashion a remedy. And year upon year, they have to go back and look at the statistics and the result of the plans they impose to determine whether the goal has been accomplished. This one's a U.S. Supreme Court case, and it talks about this. It says, traditionally, equity has been characterized by a practical flexibility in shaping its remedies and by a facility for adjusting and reconciling public and private needs. And this one goes right to what I was talking about earlier under Oklahoma law. Once a right and a violation have been shown, the scope of a district court's equitable powers to remedy past wrongs is broad, for breadth and flexibility are inherent in equitable remedies. So, you know, you can read that, and we cite it in our brief. That's the whole key here. This, when you get into equity, it's just different. And once you find that there's been a violation, you have to fix it. We cannot stop short. You know, another example of this, we cited some in here, prisoner cases. There's a lot of different kinds of these, and Judge Burge will talk about that in a minute, so I'll skip that. Let's just kind of stop there for a moment. The evidence was, again, that this problem would take more than 20 years to fix. The defendants cross-examined our witnesses about the ideas or the plans that they had and the cost of those, whether they may or may not work and what the cost might be. Never did the defendants put on a single witness to say that it would be something that could be fixed in a short period of time. Never. Now, you said on page 41, paragraph 60 of your order, though several of the state's witnesses testified that the plan will take at least 20 years to work, the state did not present sufficient evidence of the amount of time and cost necessary beyond year one to abate the opioid crisis. Now, let's just stop there. It's not a motion for new trial. I will tell you, I think that's just wrong. The Commissioner of Mental Health said here, Jessica Hawkins said here, Dr. Croft said here, Dr. Beeman said here. All of them said this is going to take years and years and years. And all of them said it will take at least 20. Now, you as a fact finder have a right to believe what you believe. If you listen to those four people under oath, including all of them, including the Commissioner of Mental Health, and said, you know what, I just don't believe them, I don't find them credible. I'm surprised by that, Your Honor. But if that's what you truly believed, then you don't have to do it for 20 years. But what I submit the court must do is continue its jurisdiction over this case for the time being that Your Honor believes will be sufficient. Because that's your job. That's why it takes moral, legal, and factual courage to do this job. And that's why I said long ago, I think in summary judgment, I thought you were the only one that could do it. You can't stop short. And certainly, the evidence isn't that 1 year is enough. We'll take 1 year, but it's going to take more than that. And the evidence was crystal clear on that. I don't think a 1 year order will stand. I don't think it can. Because if there's a nuisance, equity requires that it be abated. And it's really, to me, that simple. If you go to the next one. The testimony, you know, from Commissioner White on this was clear. 30 years to abate. If we do not abate it, more Oklahomans will die, more Oklahomans will develop opioid use disorder, more children will be born with neonatal abstinence syndrome, and on and on and on. We know that to be a fact. How do we know it? Because we've all lived it. We've all lived it. This thing has been going on for more than a decade, and it's gotten worse and worse and worse. The state of Oklahoma stemmed the tide, but they said they couldn't continue to do it without this remedy in place. That's why they came to you to have it done. That's the Commissioner of Mental Health. 30 years. Not one, 30. And if we go and we look at the statute that authorizes the Attorney General and his broad power to deal with a nuisance, he has the ability to seek criminal penalties, or he has the ability to abate the nuisance. And that word abate has a very clear legal meaning. It means nullify, not put a dent in. Nullify. That's what's required. I'm not going to go through all this testimony again, but you know, we have it in here. This is Julie Croft talking about it. Hers saying it'll take at least 20 years. Now, I'm going to save this for Judge Burge and let him come back. I mean, he'll talk about this. But one of the unique, flexible things that the law allows here is the use of a special master if you deem it appropriate. You know, we talked a lot about the Conagra case out of California. You know, what happened there was the court ordered there to be $1 billion, I think $1.1 billion payment put into a fund that could be remitted back if some of it wasn't used. You know, courts have a lot of flexibility here. We could have done that here, said $17 billion, had you awarded that, then it didn't get all used. Maybe in year 10 you found that the nuisance was gone and the money wasn't needed, could have been remitted. The point of that is there's a lot of ways to skin the cat. We felt it best to show you the plan projected out. But what has to be done, in our opinion, and you've already taken part of the step here is with continuing jurisdiction, is to come back year on year. And it happens all the time in equity. Evidentiary hearings, briefing, parties will come back. Usually there's just an argument, paper submissions, and the court will say, abated, not abated. This worked, this didn't. As long as they're on notice of what was requested, I think you have the complete broad plenary power to do what needs to be done. Judge Burge will talk about the special master thing in just a moment. Now, the last issue buried within this that I'll address, I know you mentioned 5, I had 3, but I can talk about whatever else you have questions about. You know, I said we read your order as $572 million. We read continuing jurisdiction to say this would be an annual deal where we come back, that you were limiting it to year 1. As I said, I can't get into your head. But that's the only way we could read your order from our perspective because of what we believe has to be done here. I think it would be really great if somebody else would step in and abate the crisis, but nobody has, including J&J. And they're not going to do it anytime soon. They already filed an appeal, which I don't know if your honors are aware that appeal got dismissed yesterday. Be the same reasons as the motion for new trial comments you made earlier. The court found it was premature. But they're not going to pay it willingly. So the other option to read your order is that you truly meant 1 year. If your honor truly meant 1 year, the 1 year abatement plan was $870 million and $586,000. As you know, that abatement plan was comprehensive and had many components. What the defendants have done is to say that because of the way you itemize certain parts of that order, that you made about $107 million typographical error because you gave too much money for one category. We don't read your order that way. We read the order to be adopting our abatement plan. It's the language I read you earlier, that our abatement plan is fair and reasonable, and you're going to award or order the remedy within the contours of that. I looked through what you did, and there were some categories that we requested money where you gave us the exact amount. Some parts where you did less, some parts where you did a little more. We do not read that order to be finite in the sense that it's these specific things and these specific things only. We put on weeks of evidence about that abatement plan. Very, very broad testimony, a lot of documentation, a lot of expert testimony, a lot of fact witness testimony that shows that year 1, the record fully supports up to $870 million. if you determine that that 870 is really only 572, 572 is fully supported by the record. There were so many categories in the abatement plan that you adopted and defined as our abatement plan that you didn't discuss. That doesn't mean that the evidence wasn't there to support the full breadth of an order at all. And so that's where we are on that. The record is what it is. It's full. I will tell you, we take great pride in the ruling that you made. The findings of fact, we put a lot of our effort into that on the existence of a nuisance. I appreciate what you found, and I think it's dead on with the facts. I also appreciate what Your Honor did in reaching an order that you think was fair and just. I just know in my heart, because I've lived it, and I know from the evidence that $572 million is a dent. It will take years upon years. Your Honor's order is broad enough to allow us to come back each year or however so often the court directs and to determine whether it has in fact been abated. And before I pass to Judge Burge, I'll just say this, Your Honor. Again, I said this 10 times. I can't get in your head. I can't even suppose to guess what the burdens you faced here in this case are. But I do know this. The state's still suffering. Hadn't gotten any better. People are dying. They're going to continue to die. You talked a lot about neonatal abstinence syndrome in various parts of your order. All these problems are just too real. And to stop short of doing what has to be done here, that would be terrible. You're the only person in the state of Oklahoma that has the power to fix this. And you have taken such a giant step. And I just hope, and I believe, that that step requires your continuing jurisdiction to be the way we read it, which is that we come back year over year. Judge?
Your Honor, the concept of a court having and continuing jurisdiction and maintaining jurisdiction over a case is not a novel concept in Oklahoma. It's been done before. One example is the Battles case, which dealt with prison conditions. I was in law school when that case started, and I heard about it in law school. Little did I know that I would end up with it. But it dealt with conditions at the prison, which was not a popular subject, of course, but medical conditions was one of the last that there was a finding that those medical conditions were not sufficient, and they had to be remedied. And the court, at the direction of the 10th Circuit, said the condition exists and it's got to be fixed. It's got to be remedied. And so the case went on for some period of time, for years, but at the end, to address the medical conditions, it wasn't as easy as saying, go fix those medical conditions. You had to receive reports. The court has to have help. What are those conditions? What has been done to remedy those conditions? Are we at a point now where no further jurisdiction of the court is needed? And a court needs assistance in doing that. And a special master wasn't used in that case, but it was something like that, where reports were received about the conditions at the various facilities, what was being done, what else needed to be done, and heard evidence about what progress was being made, what else needed to be done, entering orders, and using that process and using the assistance of others. It worked. We finally got the conditions met, continuing jurisdiction, and got the problem fixed. So in this case, the court has found that there is a nuisance. The court is obligated to abate that nuisance. to do whatever is necessary. And I completely understand if there's not a fixed number of years that you believe will abate the nuisance. But what is the harm because of this tragedy? What is the harm of you looking at it on an annual basis and saying, where are we? What has been done? What else needs to be done? Well, that way there's no speculation. You hear it annually, what's going on, and if further abatement remedies need to be taken or given, you can give them. You can let the special master make the findings, and then they can appeal them to you, or you can make those findings, however you want to do it. But that's what it's going to take to abate this nuisance. I submit to you that all of Oklahoma has been saddled with this undeserved nuisance. They didn't ask for it. The taxpayers didn't ask for it. They didn't ask for the financial burden. And the court has found that Johnson & Johnson played a significant role in creating this nuisance. They need to fix it. If you make a mess, you gotta clean it up. And it needs to be done to where it's complete, not partial. So I submit to the court that you do have continuing jurisdiction, that it's going to take some time to abate this nuisance. To be fair to everyone, look at it on an annual basis and see what needs or does not need to be done. Use a special master if you desire, but using that methodology under your retained jurisdictions is what's fair to the people of Oklahoma, the taxpayers of Oklahoma. Thank you. General Hunter would like to make a brief statement also,
Okay.
Your Honor.
Judge, this is the most important case that you and I will ever be involved in. And I don't want either of us to look back on this case and lament that we have left anything undone that should have been done. As I have said with some frequency, I believe your stewardship and decision-making in this case has been wise and fair-minded. But today, the final chapter in this historic trial will be written. You will write it. And I implore you today to responsibly and yes, heroically close the book on this proceeding by holding this defendant accountable for their actions. Actions that you have found are the cause of the opioid epidemic in our state. Require them to pay completely and entirely for the abatement of the public nuisance you have determined, Judge, that they caused. Your Honor, Oklahoma taxpayers have done all they could to mitigate the decades of injury to the health and welfare of our citizens. It is not fair, and they should not be asked to pay anymore. Thank you, Your Honor.
Thank you. All right. We'll recognize Johnson & Johnson. Mr. Brody?
Your Honor, I believe that Mr. Sparks needs to hook up to an
Okay.
HDMI cord. We might want to take 5 minutes.
Why don't we just take a brief break? We'll start back up right at 2 o'clock, okay?
Thank you, Your Honor.
All of you help, I can't help you, but.
excuse me.
No, I'm sorry, I didn't want to pull it while you
There you
were on
go.
it, sorry.
There you go.
I'm pretending like I'm helping, because I feel like. You got enough, John? I'm trying to help here. I'm pretending like I'm helping. Okay, I'm just pretending.
Everything good?
Really?
Well, that's a good question. So they took me off the antibiotics. Today is day 6. I was on 6 weeks. And there's no way to tell. If it's working, that's where the titanium is. So they have to wait. So they said usually on the first 2 weeks, they'll come back with it. So how do I know? They said, oh, don't worry. You'll know. You'll start fever, your knee will blow up, you'll feel like you got the flu. So what do I do? They said, you call us, we'll put you in surgery with red balls. Hopefully not. Leave me without a knee
Yeah.
for 3 weeks. And then put a bunch of antibiotic stuff with cord. And then take it out, put a hole in the knee. So I'm cautious about this stuff because usually it comes back quick. But it's just one of those.
Hasn't come back yet, so.
6 days, I feel great. And it's, you know, it sounds like that usually it comes back quickly, but it can come back as late as a year. They said about a year. So, you know, I'm just grateful to be alive. I almost died the day of the birthday.
Judge told me that.
It's a miracle.
That hearing's down here.
It's a miracle.
General Hunter, how are you, sir?
How you doing, Judge? Just saying you have everything. Good. All right. So, for your family here today, I hope you know.
Careful.
Oh, where is she?
Yeah, she's down there in between.
Oh, there she is.
Someone else on my part.
And that's what Judge, did you have water?
That's ours.
Okay, because I wasn't sure if this was my water.
No, I have to have a heart over it. Larry.
You may be seated.
Serena was finally.
Some things never change, right? Don't trip. Angie's proving once again she's talented, as all my staff are. Mr. Brody, you're recognized.
Thank you, Your Honor. And if it's all right with the court, I'm going to address the question of the new remedy presented by the state in its argument, as well as the question of the potential typographical issue in the judgment. And then Ms. Strong is going to address the settlement credit issue. And between that, I think we're going to cover everything that was argued by the state and that has been raised in the briefs.
Great, great.
So the court asked the state, when it announced its judgment on August 26th, to prepare a journal entry finalizing the August 26th judgment after non-jury trial. Instead, as we've outlined in our objections, what the state submitted was a proposed order that attempted to rewrite what the court did and to cast aside and set aside specific findings that the court made after it considered the parties' post-trial submissions, considered all of the evidence at trial, and then took the time that the court spent to prepare its judgment after non-jury trial. And Mr. Beckworth started his argument today by saying that the record, in his view, was as robust and complete as any I've been a part of. And yet, we're in a situation today where, notwithstanding that, the state has come in and is arguing that one of your primary findings, as well as the statements you made in open court on August 26th, should be set aside, notwithstanding what they've acknowledged was a full 7-week trial and the court's consideration of the evidence after that trial. You know, we also heard Mr. Beckworth indicate that he doesn't think a 1-year order will stand. Those were his words. And what we have heard from the state today is an argument against what the court specifically found and what the court specifically ordered. Now, clearly, if the state takes issue with what the court ordered, the state can take that up on appeal, and I'm sure they will if the counterpetition, protective counterpetition that they filed is any indication. That's where we are right now. But I want to get into the substance of it because there's no basis for what the state has asked you to do today. And the reasons fall into 3 categories. We see them up here. First of all, and I think this one carries the day, and we really don't need to get past it, is that the state has ignored the court's decision. Second, there's no support in Oklahoma law for what they are asking the court to do. And third, the state's proposed judgment violates both res judicata and separation of powers principles. And so let's talk through each one of those. There was no ambiguity in the court's judgment. The court found, and this is at page 41, paragraph 60 of its judgment after non-jury trial, the state did not present sufficient evidence of the amount of time and cost necessary beyond year 1 to abate the opioid crisis. Now, we heard from the state today that they disagree with that finding, and they are entitled to disagree with that finding, just as Your Honor knows defendants disagree with a number of the court's findings as well, and we intend to, have those looked at in the appellate courts. The state clearly disagrees with this finding, as we heard from Mr. Beckworth. But what we heard in the context of that disagreement was simply re-arguing the evidence that the court heard at trial, re-arguing what was presented in the parties' competing proposed findings of fact and conclusions of law, and arguing against the court's specific finding. Now, Your Honor is aware, notwithstanding the state's citation to testimony from Ms. Hawkins, from Commissioner White, from Julie Croft in its brief, and again today, that there was a significant disagreement between the parties, and there was a significant amount of evidence and argument against what the state put forward as the necessity and its view that it had established the need for an abatement remedy to last 20 or 30 years. Now, this is something that's critical. That is what the state chose to pursue at trial. What the state did, the state said, we're going to come in, we're going to try to prove that the defendants caused a public nuisance, that it can be abated by a 20-year abatement plan to a 30-year abatement plan with these costs that we've assigned. The court found that there was insufficient evidence to prove that. That's where we are right now. And, you know, a number of the things the court considered, it was specifically the testimony that we saw cited today by the state. And this is, again, from the court's judgment, though several of the state's witnesses testified that the plan will take at least 20 years to work, the state did not present sufficient evidence. And that was Your Honor's finding, a finding that the state now disagrees with. This is just a couple of slides I pulled out from the closing argument deck that Mr. Ottaway used. This is something that was argued to the court. The court considered competing testimony. The court considered cross-examination. The court considered what had been proven and what had not been proven. There's no better example of that than in the list of items that the court included in its findings, in its abatement plan. They included certain things that had been presented by the state for that first year. It omitted others. You know, we had doctor after doctor come in and say, we don't need to be re-educated. And so those portions of the abatement plan on re-education of doctors were not included in the court's findings. So the court heard the arguments, the court heard the evidence, the court heard Mr. Ottaway in closing argument argue this exact issue based on these very slides that we have pulled out, and the court made its decision. And if that wasn't already clear, the court made it very clear what it felt constrained to do when Your Honor announced your decision on August 26, 2019. As I detail in my judgment, this is the amount of cost that I am constrained to order Janssen and Johnson & Johnson to pay based on the particulars of a nuisance claim and the evidence that was presented at trial, whether additional programs and funding are needed over an extended period of time. Those are determinations to be made by our legislators and policymakers. The court had ample grounds for its finding. You know, we disagree, even that Janssen and Johnson should be liable for the $572 million that the court found in its judgment, but the court had ample evidence upon which to base the finding that appears in its judgment regarding the insufficient evidence proffered by the state. And in the case law, this is exactly the way it works. You know, we heard from the state that the court has to maintain jurisdiction, that having found an abatable nuisance, the court needs to retain jurisdiction over the case in perpetuity, even though the court found that the remedy that was put forward by the state, that the state elected and made the choice to present at trial, was not supported by sufficient evidence. And that's just not the law. We heard from the state, and I wrote it down, that the court must maintain equitable jurisdiction in this circumstance. But the case law doesn't stand for that proposition. What the case law tells us is, and this is the final bullet point, and this is the most important one on here, relief is confined to and restrained by the evidence. And that is true for injunctive relief as it is true for any other remedy. And so when the state cites in its briefing and cites today cases about, you know, for example, removal of pollution from a property where mineral exploration had been going on and remediation is required by a statute, or the reduction of noise and dust at a quarry, that's very different than a situation where a court has found insufficient evidence to support a remedy requested by a litigant after a trial. And the litigant is then coming in and saying, give us another chance. Let us come in a year from now, let us come in 2 years from now and try to prove what we were unable to show at trial, that additional years and additional money is going to be required. And that's why, you know, the court in that circumstance wisely commented on August 26th that such future determinations should be left to legislators and policymakers in the state of Oklahoma. The Crust Stone case that was cited by the state is the perfect example of this. You know, there were 3 questions that got taken up on that petition. The first one, comparative injury, is not relevant here today. The second was a sort of a coming to the nuisance kind of question, not relevant here today. The third one is, did the evidence support an order requiring removal of rock stockpiles that led to the blowing of fine agricultural limestone dust onto the plaintiff's properties? And so, it was a question of, in that case, the noise from the quarry operations, the blasting, and then as a result of that, whether it was the blasting, whether it was trucks going up and down the road, whatever it was, dust blowing onto neighboring properties, almost looking like snow on the trees sometimes. And the key point is, the court found that there was evidence offered at trial to support the fact that these rock stockpiles and this agricultural limestone dust, that was blowing onto the neighboring properties. Now, if there had not been evidence supporting that fact, the court couldn't have ordered it. And so Crust Stone is entirely consistent with what the court did here. The court found what the state had proven, what the court felt the state had offered sufficient evidence of, and what it had not. And its ruling reflects that. And so, the other case that they pay a lot of attention to in their brief but didn't mention today, the Minders case, that was a case brought in connection with requirements of the Oklahoma Environmental Quality Act, which specifically 27A OS section 26102 has specific requirements for remediation. And that was a case where the court ensured that the statutory remediation of mineral pollution on the surface and subsurface levels was carried out to fulfillment. That's a nuisance per se case, and it's a different circumstance than we have here. So the state would have the court, and this is what we heard today, and it's somewhat remarkable to go through a 7-week trial where what is being argued and what is being litigated is whether the state is entitled as a remedy to a 20 to 30 year set of programs and initiatives in an abatement plan, to have the court find that there was insufficient evidence to support that beyond the first year and to support a certain portion of it, and then to come back into court and hear, well, maybe we should do something different. Maybe we should appoint a special master, reconvene annually, and decide what type of funding and appropriations to state programs are going to be necessary on an ongoing basis. It is a novel theory. It is not novel only because, simply because it was not mentioned at trial. It is novel because of what it would involve. It would be a situation where district judges, the courts in Oklahoma, were empowered to, year after year, engage in a de facto appropriations type of process as part of a nuisance action. And there is no support for that type of procedure in Oklahoma law. We haven't seen support for that in Oklahoma law. And we don't see support for that in what were proffered as analogous federal cases involving constitutional rights. Very different situation. There's no constitutional right at issue here, such as the right to go to the fact that segregated schools, separate but equal, didn't work. That's Brown. And then a series of cases after Brown, as lower courts attempted to address the Brown holding, where, for example, the Swan case that Mr. Beckworth cited, the Charlotte-Mecklenburg school district, where there were contentions that the school district wasn't complying with the Supreme Court mandate. It's a very different situation than what we have here under the nuisance law structure, where there has been evidence put forward and a request made on an abatement remedy, and the court has found that the evidence was not sufficient to sustain that. And, you know, it is worth mentioning, as we have on the slide, that, you know, the school busing decisions, just to take an example, are widely recognized as cases where courts overstepped limits on their authority and called into question the legitimacy of the judicial system. And we don't want to have that situation here with a decision coming out of this court on the novel theory advanced by the state today as it seeks reconsideration of the court's August 26 judgment and its findings and the very clear, very specific comments that the court made. Now, that's not the only problem with what is being proposed. What is being proposed also violates settled principles of res judicata. You know, we could have cited any one of a number of cases for this idea. We all know what the principle of res judicata means. We all know what issue preclusion and claim preclusion are. In a situation where the state has come in and said, you know, we're entitled to a multi-year abatement remedy, we're entitled to, you know, this number of dollars per year going out 20, 30 years, and has not offered sufficient evidence to support that. And the court has entered a specific finding saying that notwithstanding the testimony from certain witnesses that it would take at least 20 years, the state did not present sufficient evidence to allow the court, the state to then come back a year later, 2 years later, 5 years later, 10 years later, and try to prove what it did not prove at trial would violate settled Oklahoma law on res judicata, claim preclusion, and issue preclusion. It would also violate the separation of powers. And, you know, we've cited the Oklahoma Education Association decision a number of times, and the state responds each time, well, you know, that case is a little different. We're not asking for an order requiring the legislature to do anything. What they're doing is worse. They're trying to go around the legislature entirely and pull what the court observed in its comments as the process that should be followed into the court and completely out of the legislature. And so what they are proposing, this idea, not simply that a, you know, court would oversee, for example, busing as a means of desegregating segregated schools, but that the court would come back in and say, okay, we're going to sit down again, and we're going to look at things, and we're going to decide how much money we need to add to this program over here, we need to add to this program over here. You run into serious separation of powers principles with no support for the procedure, for the idea that having offered insufficient evidence at trial, the state can now come back and say, we're going to do it all over again, and we're going to go through this funding process, and we're going to go through the same proof that we tried to put on during the trial in support of the abatement plan. We're going to do that again. There's simply no support for that in Oklahoma law. And so the court recognized, again, and I think we need to come back to this, the court specifically recognized, you know, what is supposed to happen and what should happen here if the court's judgment is upheld on appeal, and this, whatever the number ultimately is implemented as it has been set out by the court, that whether additional programs and funding are needed over an extended period of time, those are determinations to be made by our legislators and policy makers. And again, the mere fact that the court is sitting in equity doesn't change any of this. The Henshin case that was cited, the Ellis v. Potter case that was cited by Mr. Beckworth, none of those cases empower the court to retain jurisdiction in this circumstance to hold new hearings, to require additional funding. I mean, the Ellis case, that was an action to quiet title on a deed to property, and it really stands for nothing more than the uncontroversial proposition that a court with equity jurisdiction has the ability to afford relief based on the evidence presented at trial. And that was actually a case where, though the trial court found that evidence warranted cancellation of a deed under its discretionary authority, it withheld cancellation. It didn't even go that final step. But it's really, it stands for the uncontroversial proposition that a court's decision in equity should be based on the evidence. And the court's decision in equity, just as the court's decision in Ellis was based on the evidence, the court's decision here should be based on the evidence and should be based on its specific findings as the court explained them in its comments on August 26th. I do want to address just one final point, and you heard a reference to ConAgra. And you know, first of all, as we have, and I don't want to get into the nuts and bolts of ConAgra. I know we've been through that a number of times in the course of arguments in the case. But the interesting thing about ConAgra is there was a single sum of money awarded by the court in ConAgra. This was not a situation where there was this idea that, well, if what you have proven to be the amount of money required for this lead paint remediation is not enough, you come back and you can get more money. In fact, it was simply, this is the amount, and if there is any left over after this remediation period, it will revert to the defendants who funded the amount. And so even ConAgra doesn't support what the state is putting forward here in what is nothing more than a request based on an entirely new proposed remedy to have the court revisit its findings and to have the court reconsider and change the opinion that the court announced and entered on August 26th of this year. The state's brief has a passage at the very end, and it's, I got it, Rich, thanks. They wrote, the court has the power to fashion whatever remedy it sees fit, reading from the brief they filed last week. Now, obviously, the court only has the power to fashion remedies that are supported by the evidence, but that's exactly what the court did here. The court reviewed the evidence and, taking the language from the state's brief, the court fashioned the remedy it saw fit in this circumstance. With that, Your Honor, I would like to turn to the question of the amount in Your Honor's order for the NAS treatment evaluation standards, if I may. Walking through the court's findings, walking through the abatement plan step by step in the order that the court entered on August 26th, you can see, looking for each item, exactly where the number that's in the court's opinion comes from, step by step by step. You can look at what the state presented as costs over time for various services, and you can, match it up. And as we pointed out in our objection, there's one place where there appears to us to have been a typographical error in the judgment, and that's the NAS treatment evaluation standards. That's page 35, paragraph 27. And it's a situation, and we've laid this out in our brief, where if you go to the exhibit that's cited in the paragraphs that describe that service, and you look at what the state presented as the cost, you come to a number, looking at the cycle that the cost run on, of $107,683. The judgment itself makes that 107 million. It's something that can easily be corrected. The state has not offered an explanation or pointed to any evidence that suggests that it was anything other than a simple typographical error. We've prepared a proposed judgment that includes that correction, and it's, if I may, we could mark this as hearing exhibit 1, Your Honor.
Yes.
It also includes the settlement credit that Ms. Strong will address. Now, the state's response on the NAS treatment services has been that, well, it could have included other items. It could have included treatment for, you know, what we all recognize as the tragedy of babies born with neonatal abstinence syndrome. But looking at the court's judgment, it's very clear what the court did and did not include in those areas. The court included in its judgment each of the NAS elements. They were outlined in the state's plan as N1, N2, and N3. They were so designated. Each of those items is included in the court's judgment. Prenatal screening is at page 36, paragraphs 30 to 32, and medical treatment for infants born with NAS or suffering from opioid withdrawal is at pages 36 to 37, paragraphs 33 to 35. So what we have presented to the court and what we've asked to be marked as hearing exhibit 1 makes that mathematical correction. Last point, though, Your Honor, this idea that 572 is instead 870 is something that is likewise not supported by the evidence in the case. The court was very, very clear, and in its judgment, it's very, very clear going through. You can look at the abatement services that were included. You can look at the parts of the abatement plan presented by the state that were not included. We see things like community prevention, higher ed discretionary prevention funds, public education. They're all within the treatment, various parts of the treatment category. But the court was very clear about what it did and did not include in the abatement plan in the court's order. And so, you know, I think that the idea that 572 is really 870 finds no support in the court's judgment, and it certainly finds no support in the record as the court made its findings, presented its findings in its August 26, 2019 judgment. And with that, I will turn it over to Ms. Strong, who is going to address the issue of settlement credit.
Thank you, Mr. Brody.
Good afternoon, Your Honor.
Good afternoon.
Sabrina Strong on behalf of the Johnson & Johnson and Janssen defendants. As Mr. Brody indicated, I will turn to the portion of the argument to address the settlement credit issue. As reflected in our papers, Your Honor, we believe that the judgment must, at this time, reflect a settlement credit. The credit is required under Oklahoma law. There is a contribution statute that specifically requires it. The state's claim that Janssen failed to timely request that credit is without basis. The state has already admitted that the Janssen defendants are entitled to this credit, and the court's own findings of fact confirm that these defendants are entitled to that credit. I will walk you through each of those points, Your Honor, at this time. But first, I'd like to start with the statute itself. The statute is 12 OS 832, and it specifically provides that when a release or a similar agreement is given in good faith to one of two or more persons liable in tort for the same injury, it does not discharge any other tortfeasor from liability for the injury, but it reduces the claim against others to the extent of any amount of the consideration paid. That's what the statute provides for, and that is the basis for the settlement credit. It is required under the statute. We are all very well aware of the settlements of the other defendants who were in this case, Your Honor. Teva's settlement, $85 million, is reflected on the slide. And Purdue's settlement in the amount of $270 million is reflected in the slide, totaling $355 million. That is the amount that should be reflected in the judgment of the settlement credit that should be applied. And the reason for this settlement credit is that it codifies the law. This statute codifies the law in Oklahoma that double recovery is not permitted. When a fact finder, the court in this instance, determines the scope of the harm, the plaintiff is only entitled to recover the totality of that scope. It cannot recover more. And what the state's lawyers are arguing here is that although the court found that the totality of the amount that needs to be paid is $572 million, that in fact the state should recover more than that, $927 million, when you take into account the amounts paid by Teva and Purdue in their settlements. That is not permitted. That violates the principles of double recovery, Your Honor. So I'll walk through the various arguments that the state has made. One of the first arguments the state says is that the Janssen defendants failed to timely request a credit. There's no basis for that, Your Honor. What you're looking at here is an excerpt from your own pretrial conference order. You issued this on May 23rd, 2019, at the outset of the trial, and it reflected the submissions of the parties, and then you issued an order. And in that order, at page 52, paragraph 32, as to Johnson & Johnson and Janssen, it states, should J&J and or Janssen be held liable to the state, J&J and or Janssen would be entitled to a credit or set-off for all sums of money received from or on behalf of any other parties liable for the same alleged injury. We plainly made the request at the outset of the trial, Your Honor, and it's reflected in the trial court's pretrial conference order. Not only was it reflected there, Your Honor, but on May 24th, again at the outset of the trial, the Janssen defendants submitted a trial brief to Your Honor, and in that trial brief, it says, and this is up on the slide, under Oklahoma's contribution statute, Janssen and J&J would be entitled to a settlement credit of $270 million against any joint and several award to account for the state's settlement with Purdue. And I should note here, Your Honor, it's reflecting $270 million because at that time, as you will recall, only Purdue had settled at the time of the filing. And so that reflects the totality of the Purdue settlement, and it does not yet reflect the Teva settlement that comes later, Your Honor. But there's no merit to the notion that this request was not timely made. It absolutely was, Your Honor. Not only was the request timely made, but after the presentation of the evidence. And in the state's proposed final judgment submitted on July 31st, 2019, the state itself wrote, under Oklahoma law, and this is at paragraph 23 of the state's proposed findings of fact and proposed judgment. Under Oklahoma law, defendants are entitled to a settlement credit in the amount of $355 million to account for the settlements entered between the state and the former defendants who settled and were dismissed. It doesn't get much clearer than that, Your Honor. They were aware of the settlements, they were aware of the evidence at trial, and they presented a proposed finding and conclusion to Your Honor, indicating quite clearly that the defendants are entitled to a settlement credit. And I want to focus your attention on a footnote in the proposed findings of fact and conclusions of law, July 31st, 2019, at page 618, footnote 116. Purdue, this is what the state wrote in that submission after trial. Purdue and Teva are no longer parties to this action. The settlements involving those parties are to be reflected in the judgment by way of a dollar-for-dollar offset. So, why the change of heart now by the state? The only difference, the only change in fact at this point is the judge's finding as to an amount. In the proposed findings, when the state was asking for billions of dollars, they made very clear that the law would entitle the Jansen defendants to the credit. When the state did not recover the billions of dollars that it anticipated and hoped it would get, and was disappointed with the amount, it changed course and changed its argument about the settlement credit. That's not the way a settlement credit analysis works. It doesn't turn on the amount of harm found by the fact finder, the amount of the reward or award that would be issued by the fact finder. That's not the proper analysis. And the state has made an argument that, I'll go back to this, onto the proposed, here what we're looking at is the proposed findings of fact and conclusions of law submitted by the state. And the state noted, you heard today from Mr. Beckworth, that the Jansen defendants didn't include in their proposed findings of fact anything about a finding of liability as to Purdue and Teva, and that is a problem for the credit now. That makes no sense. The Jansen's defendants did not include a proposed finding of liability as to Jansen or Johnson & Johnson. Why would it have included a proposed finding of liability as to other manufacturers? That makes no sense. That, we believed, was inconsistent with the law and inconsistent with the facts presented at trial. Your Honor disagreed and found liability, and in the context of the proposed findings that the Jansen's defendants submitted, we did contemplate that in the event the court were to find liability, we asked that the court apportion that liability, and we left a blank for the court to consider that. The court failed to apportion liability. Had it apportioned liability, we would be talking about the amount owed based on the apportionment that the court had found, but the court didn't apportion liability. Accordingly, we are left in a joint and several liability scenario, and only now, under these facts, is it clear that the court must include in its final judgment a settlement credit for the amount that was paid by Teva and Purdue. And so, again, with this change, now understanding what the court has awarded, the state includes in its paper filed October 10th just last week, for the very first time, that there was no evidence. I want to read exactly what was submitted in that paper. Quoting, the state wrote, there was no evidence whatsoever regarding Purdue's or Teva's potential liability was ever put into the record by the state or J&J. Your Honor, we all were at the trial, the 7-week trial. It's hard to understand how that sentence could be written. I would say that almost no day went by in that trial where we didn't hear the accusation that the Janssen defendants partnered with Purdue, or something about the Teva defendants and how Teva created the need and wanted to sell to the need, and that Janssen did just the same thing. We all are very well aware that there was extensive evidence and argument about Purdue, about Teva. Documents were submitted. We had many arguments over the admissibility of Teva and Purdue evidence, and that was admitted at trial. And in fact, Mr. Beckworth referenced a motion in limine where the Janssen defendants asked that evidence related to Purdue and Teva be excluded for certain purposes in this case. And the state opposed that, and the Janssen defendants lost. And the result of that was there was extensive evidence related to Purdue's conduct, extensive evidence related to Teva's conduct, and the import for the case. And in fact, at one point, I recall poignantly Mr. Beckworth announcing to the court that this case is not about their drugs, meaning the Janssen defendants' drugs. And the court's own findings are consistent with what we know happened at the trial and the evidence that was put on at trial relating to Purdue and Teva. And I'll just reference a few of your own findings, Your Honor, where you reference that evidence. You found that Janssen acted in concert with others in marketing prescription opioids, and you pointed to Purdue. And the evidence you cited is put up here on the screen, Your Honor. With respect to Dr. Kolodny's testimony, the testimony was in 2007, when Purdue Pharma was convicted criminally of claiming that OxyContin was less addictive because of its extended release formulation, Johnson & Johnson continued to do exactly what Purdue Pharma was convicted criminally of doing. They promoted their products as having lower abuse potential. That was testimony from Dr. Kolodny that you cited. The next quote is from Commissioner Terry White's testimony, where she said, in 1996, Purdue, Johnson & Johnson, Janssen, and a host of other people began in targeting Oklahoma and other states with this type of marketing. Your findings go on to reference Purdue's success, and I'm quoting here from page 9 and paragraph 17 of your August 26 judgment. You noted that, quote, in marketing OxyContin for chronic non-cancer pain, you talked about testimony that referred to flooding of opioids into the United States and Oklahoma, and you pointed to Dr. Kolodny's testimony. Again, that's up on the screen for your reference. There were other findings, Your Honor, in your August 26 paper. You pointed to evidence that Purdue and Teva used and supported the concept of pseudo-addiction, which you faulted Janssen for referencing. And you also pointed to testimony indicating that the entire pharmaceutical industry targeted primary care physicians in marketing opioids. So there's no notion, there's no support for this notion that there was no evidence at trial, Your Honor. We know that there was evidence at trial related to Purdue and Teva, and your findings reflect it and reflect your position with respect to what their liability. This is the last piece of evidence or pieces of evidence that I'll reference from your proposed or your judgment on August 26, Your Honor, in reference to Janssen's and J&J's former subsidiaries, Naramco and Tasmanian Alkaloids. You made a finding that Teva and Purdue bought API from those former subsidiaries, and the relevant paragraphs are excerpted here. You noted that defendants through these subsidiaries supplied the following APIs to other drug manufacturers in the United States, including Purdue and Teva. Again, this is in your August 26 findings at paragraph 12. You noted through Naramco, defendants met the anticipated opioid demand by selling API, including oxycodone, to Purdue. At paragraph 14, through Naramco, defendant supplied API to other opioid manufacturers, including Teva. So in light of this evidence, Your Honor, in light of the fact that the Janssen defendants requested the settlement credit, in light of the fact that the state absolutely admitted that we are entitled to that settlement credit, and in light of Your Honor's findings as to the Teva and Purdue conduct that are reflected in your August 26 paper, Your Honor, all of those pieces together demonstrate and indicate that the court now at this time must have the settlement credit reflected in the final judgment. To the extent that the state has cited cases arguing that it's too late, again, I think there's no basis for that factually in light of your pretrial conference order and our pretrial brief indicating that we were requesting the credit. I wanted to point out, when you're going over the papers, something that I thought was interesting about the way in which the state represented the case law. The state refers to the Nichols case, as do we, Your Honor. And the Nichols case makes quite clear that the court has until the very end, before the fact finder is discharged, the court can, in fact, make a finding of liability as to other joint tortfeasors, and can at that time implement a settlement credit. It is not too late even now. Had you not made your findings, which we believe you absolutely did and are sufficient, and the state acknowledged that by its admission, but had you not, the Janssen defendants can still make that request now and would ask that you do so to make a finding of liability as to Purdue and Teva, consistent with the theory espoused by the state, the nuisance theory espoused by the state, and as adopted by the court in its ruling. We don't believe that's necessary because we believe the findings already reflect that, but it is certainly not too late under the Nichols case. It makes clear that a non-settling party can request a settlement credit through either a pre-submission objection to the trial court's form of verdict or a post-submission objection before the jury's discharge when the verdict was brought into the courtroom, but before its acceptance by the trial judge. And so in the papers that were just submitted, so I want to make sure you have this at top of mind if you go back to those papers, the state noted at page 16 in referencing the Nichols case that the finding needs to be sought before the fact finder renders its decision. That's not what the Nichols case holds. If you look on the right-hand side of the page there on the slide, Your Honor, the Nichols case talks about it's after the verdict has been brought in, but before the jury is discharged. So it certainly can come, a request can come after the jury has brought in its verdict, but before it's discharged. And of course, you are here, Your Honor, you are our fact finder, and you have not been discharged. So there's no issue on a timeliness argument here. Let's see if I can get one more. There's one more slide. There's a slide that basically the same representation was made with respect to the Payne case. And Your Honor, if you look at it carefully, the Payne case adopts the Nichols rationale and reflects that in fact it can be made, a request can be made before the fact finder has been discharged, but after it has first brought back its verdict into the courtroom. So with that, Your Honor, we would ask that the court at this time, before finalizing the judgment, that it modify it to make sure that the settlement credit to which the Janssen defendants are entitled is reflected in the final judgment. Thank you, Your Honor.
Thank you, Ms. Strong. All right, I told the parties I'd give them some rebuttal time, so Mr. Beckworth will let you do that.
It's everyone's good fortune that I've had my first case of laryngitis the last few weeks, so I'll run out of steam quickly. Now, let me just address the settlement credit points first. There's a lot there to unpack, but it's just not correct. First, I see Mr. Burns is here representing Purdue. Teva is starting a trial in Cleveland, Ohio on Monday. I'm sure that those two companies would be shocked to find out that their colleague here is now asking for a finding of liability in this case against them after the court already issued its August 26th ruling. That would have some pretty dire consequences to those two entities in their follow-on litigation. Either Mr. Burns or Mr. Coates were here every day during this trial. Representatives of Purdue, Trey Cox, and others were here every day. Nick Merkley was here every single day. Never was the liability of their clients put into evidence in this case, nor was there any evidence put in about it that would support such a finding. That's why they settled. So it just didn't happen. It would have been on them to put that evidence on, and they didn't do it. It's just that simple. I have to object to this Exhibit 1 that they put in, the proposed new judgment. It's late, it's untimely. What's interesting about what Mrs. Strong just talked about is this idea that you can come in before a jury's been discharged. Well, you are the finder of fact, and I guess you can never discharge yourself in that sense, but your findings were complete on the 26th, and they didn't do it then, and they can't come in now and put in evidence that was never put into the record now. So any such request would be untimely, and it'd be totally inappropriate. I guess they could file a motion for a new trial and argue it that way and try to put on new evidence if one were granted. But other than that, procedurally, it just doesn't work. And looking at what Mrs. Strong pulled up on their pretrial order kind of proves the point. She was reading from I think paragraph 32 or point 32. The reference there about a settlement credit referenced, and the quote was, against another defendant, quote, found liable. And that's what the Nichols case talks about. You have to find liability. That didn't happen. And Your Honor, wrote your order, but you know this. When you went through the elements of nuisance where the liability findings are, not a factual discussion of conduct that may have led to that liability, but the actual liability elements that you went through and checked each box and found, you referred exclusively to the acts and omissions of the defendants, a defined term being J&J and Janssen and the other J&J entities. That's the finding that's in place. So what they're asking you to do cannot be done. Yes, we had a statement about J&S liability and credits in our findings of fact. I think those findings were 780 pages long. There was a lot of stuff we put in there to cover every possibility here. But you didn't find those entities liable. So it cannot be done substantively. It cannot be done at this late date procedurally. And frankly, I think that's the end of the discussion. And I would also say that to their point about your findings on these other folks like Aramco, and you mentioned Purdue and Teva, you did not find joint and several liability in your order. I don't think the words joint and several liability appear anywhere on the four corners of that document, anywhere. So this idea of joint and several liability wasn't done by the court. So I'd like to just kind of turn back to Mr. Brody's argument quickly without rehashing it all, of course. Mr. Brody talked about us wanting to rewrite your order and about concepts of res judicata. I want to make sure the court's very clear about what we're talking about here. We're not asking you to rewrite your order. You asked us or ordered us to prepare a journal entry consistent with what you gave us on August 26th, and we wrote that consistent to what we believe your findings were, the evidence is, and what the law requires. That's simple. We're not asking to change some concept of res judicata and have to come back in here and prove up future monies at all. Let's be real clear about this. You adopted our abatement plan. You found that plan to be fair and reasonable. And within that document, year one's $870 million. That's why I use that number. We put on evidence to fully support $870 million. You found what you found. It was $572 million. That evidence is in there. You did not determine anywhere that our evidence of the amount on any year was insufficient to prove our case. Not anywhere. In fact, you stopped and looked only at year one and you said 572. So if that's the number we have, that's the number we have. The question is, having found that, can the court stop short of fully abating the nuisance? That's what we're arguing about. Not to come in here and argue again, is there a nuisance? Not to argue again, should there be more money in following years than we put into the evidence? They know what the limits of what we asked for are. They know what the limits of that evidence is. But your job, under the statute, under the case law, is to abate the nuisance. And what would happen if we came back in here in a year and everybody agreed that the nuisance was not abated, that 572 wasn't enough, that it fell short, and that more was needed? What would we do? Would you have fulfilled your legal obligation as a court in equity? Would you have fulfilled the oath you swore to do in this case? No. You would have stopped short. And equity just doesn't allow that. So we're not asking you to come back and have a bunch of mini trials at all. We're asking you to take the 1 year that you found to be appropriate and to come back and in years 2, 3, 4, 5, and 6 say, is it abated or not? That doesn't violate any concept of due process or res judicata or anything else. That's what abatement does. And, you know, Mr. Brody talked about Conagra and this remitter idea and said we didn't ask for it. You know, it's really interesting and just shows how disingenuous this all is. In the exhibit he just handed you, J&J specifically now asks that if the 572 isn't fully spent in year 1 to abate the nuisance, then it goes back to them. Something we've never heard them ask for before. Where'd that come from? The whole idea here is that equity is a loose concept. We have to do equity. The law and the cases that we've cited, Your Honor, quite frankly, had we come in here and said, look, we need $1 billion a year for 30 years, you could have found, if you believe the evidence supported it, $2 billion a year for 50 years. Because that's what the law requires you to do, is to abate the nuisance. So I think we have to just step back from the confusion they're trying to create. There's a difference here between whether we met our burden of proof 20 years versus your burden as the judge on abating the nuisance and your duty. So if you don't think it's 20 years, you did not issue a finding that it's 19, 18, 1, 2, or 3. You did not issue a finding that says 1 year will abate the nuisance. You didn't do that. If you believe that 1 year is sufficient to fully remedy and abate this nuisance, I think that's got to be in your order. If not, I think we come back year after year. And I think Your Honor, I would just request that you stick to what you said about our abatement plan being reasonable and necessary. Now, Mr. Brody also talked about this $107 million issue. And he said that I said what you should do is award $870 million. I would love that. I think that's what we proved, but that's, just to be clear, that's not what I'm saying. What I'm saying is the abatement plan that you found to be fair and reasonable, we put on evidence of dozens of categories and subcategories that totaled $870 million something the first year. You did not address all those. You didn't go through them line by line and say, this one they proved, this one they didn't. You went through certain components and you discussed them. Our position is that the record fully supports $870 million, so it most certainly fully supports the award you gave of $572 million. And there's no reason at all to change that. What they're asking you to do is go $572 million minus $107 million minus $355 million, leaving the state with $100 and something million. A number that would do nothing to fix this problem. Fall very short of your obligation to abate it and fall woefully short of what the plan says is reasonable and necessary. So I just want to be clear. I'm not asking you to change your 572 to 870. I think you could do that. That's not it. What I'm saying is whether you look at this one item that they're referring to or the other dozens of items in the program, the evidence in the record here, our burden that we met, fully supports 572, 590, 700, 870, or whatever the number needs to be. Your Honor, I think we could go on and on, but I know we've had a lot of time with you. I appreciate it. Again, I would just close with, we ask you to do the very tough job here in equity and give the state the full remedy of abatement, which we believe is required in law. Thank you, Your Honor.
Thank you, Mr. Beckworth.
Your Honor, I can be very brief.
Sure.
Two of our slides. This is really what it comes down to. Court made a finding. The court then explained its finding when it announced its judgment on August 26, 2019. And what we,
Mr. Hunter, do you have an objection?
Your Honor, I object. We're going to move it in this proceeding. We should be able to close the evidence.
I agree with that. I did say I'm going to let both parties have a rebuttal, so Mr. Beckworth or you will have the final say.
Thank you.
Okay.
that's fine, Your Honor. I'm going to be very brief here. Your Honor explained your ruling. You made your ruling. You explained it on August 26th. And what we have here from the state, and what we've heard from the state, is that the state disagrees with what was a clear pronouncement from the court. And the state wants to do something different than what it chose to present as the remedy at trial. And as we pointed out, the state has said you must retain jurisdiction, but the abatement cases don't say that the court must retain jurisdiction. And to go back to crushed stone as an example, if the court in crushed stone had found that there was not sufficient evidence to justify an order requiring removal of the rock piles to prevent dust from blowing in, the plaintiffs, surrounding landowners who own the land around the quarry, would not have the opportunity to come back in 2 years, 3 years later and say, Judge, we still have dust on our property. We think they've shut the quarry down. We think they need to come in and remove those rock piles to prevent this dust from blowing onto our properties. That would violate res judicata. There is no support for that kind of exercise in equity, even in any of the case law. And that's the situation we have here. We have a situation where the state has come in and said, we need something different. We need the opportunity to come back. We understand you found insufficient evidence, but we want you to retain jurisdiction to push more funding in year after year to these state programs, something that Your Honor specifically said were determinations to be made by our legislators and policymakers when you made your comments on August 26th. And so we would ask that the court enter a journal entry, final judgment that is consistent with the court's comments. We don't think that what has been presented by the state in its request for reconsideration of the court's finding and for an alteration to the court's comments comports with the law or the evidence, or frankly is even procedurally proper at this point in time. Thank you.
Thank you. Mr. Whitten.
I'm going to hobble over here, Judge. I will be very brief. I've practiced in your court ever since you went on the bench. I know you. I don't know what was in your mind when you wrote this order any more than anybody else here does. I can just read it. I do not know if you had read all of these cases that we cited in our brief about in a court of equity, you have an obligation to come back. I'll be very frank with Your Honor, in a case that went into the 8th week, no single lawyer can read everything in this case. I personally had not read those cases until after you gave your decision. So I can tell you, and from my standpoint, I did not know you could do that. I don't know if you knew it, but you know it now. And for you to take no action and leave this nuisance unabated is not just, it is not equitable. You know what those cases say now, and I urge you to use your power of equity and fix this thing. Now, that's not the way we ask you to do it. We ask you to award a lump sum. That's fair. You chose to do something different. But now you see what the law is. You said we didn't prove to your satisfaction beyond 1 year. But we all know that if you come back or you have a special master come back every year, that argument's gone. There's no speculation. If you can do it in 1 year, which you just did in your order, you can do it a year from now for 1 year, and a year from now, 1 year, and you can do that until this nuisance is gone. You have the power to do that. Nobody else does. I would urge you to do that, Your Honor, and the people of the state of Oklahoma need you to do that. That's all I've got.
Thank you, Mr. Whitten. As far as the Exhibit 1 that was offered by the defendants, I'm going to go ahead and mark that as Exhibit 1 to the hearing. I know there was an objection to that, but that will be part of the record. Couple things. There's been mention about the math error, whatever we want to call it. I acknowledge that the computing error contained in my August 26th judgment. The cost for Johnson & Johnson to pay for the development and dissemination of NAS or neonatal abstinence syndrome treatment evaluation standards, including continuing education courses, is $107,683. That will be the last time I use that calculator. I'm going to take my decision on the other remaining matters under advisement, and in my forthcoming ruling, I will include the correction to the math error. Any question from council?
No, Your Honor.
Nothing
Okay.
from us, Your Honor.
Thank you very much. We'll be done.
It's good to see you.
You might hurt yourself.
If I'm gonna take you out, it's just gonna be bigger. You didn't.
Can't help it.